Now you get to see that this is the process sometimes of going through these lives where you didn't realize that you're running out of battery on your computer, or you didn't realize this, or you didn't realize that. It's just the process of lives, and also it's the process of our lives. So I'm Deborah Sermonaro Eldridge. Welcome to your Thursday morning coffee break. So I am the attorney and owner of DCE Law, and I am coming to you live every Thursday with information in the area of family law and business startup, because those are my primary practice areas. Under family law, I also fall within the juvenile dependency system, where I represent children or foster parents who are fighting to keep their children, and so on and so forth. But that's for another time. Today we are focusing on the process of an uncontested dissolution of marriage. And when we talk uncontested dissolution of marriage, we have to talk about the two separate realms of it. There's the simplified dissolution of marriage, where you do not have children. We're going to talk about that one first because that's the quickest. Then there's the uncontested, when you have children involved. So let's go ahead and let's talk about first, what does uncontested mean? Well, uncontested means basically that your spouse, you and your spouse, are not fighting about anything. You are agreeable to everything. You both feel that you've reached a point in your relationship where divorce is the appropriate option for you, and you're going to go ahead and you're going to move forward in that realm. So with that in mind, a simplified dissolution of marriage is when you have no children involved and it is uncontested because you both agree you want to resolve the marriage and move on to the next chapter of your life. You agree on everything. You agree on how the assets are going to be split. You agree on how the liabilities are going to be handled. You agree on finances and just everything with regard to a dissolution of marriage you agree upon. There's no area of the divorce that you don't agree upon. Now, I'm going to say this to anybody who is considering using a different source other than DCE law for your uncontested dissolution of marriage in Florida. Remember, all of the information I give you is based on Florida law. So if you are in another state, you do want to connect with an attorney in that state, because I can only give legal advice for Florida. But if you are a resident of Florida and you are considering divorce, please be careful with these do-it-yourself organizations that are not necessarily run by attorneys, run by paralegals, whatever they're run by, because what they're doing is they are not filing the petitions in the counties in which the couples reside. So if you're going to do it right. That means that if for some reason there was an issue that came up and you had to address the dissolution of marriage, you have to go to that county. Well, that county could be 2, 3, 4, 5 hours away from you. So it's very important that you connect with an attorney that knows what they're doing, or you use a do-it-yourself company that does it the right way, as far as I'm concerned. So with that said, a simplified dissolution of marriage is where, as I said, you agree on everything. So you get the paperwork. If you're going to do it yourself, you get the paperwork, you fill it out, you complete it, you file the petition jointly, because you're both filing this as a couple because you both want to get the divorce. So you file it as a couple, and then you file it, because everything's e-filing now. So even if you go down to the courthouse, it's going to end up being e-filed now. And that's the e-filing system, which means everything's done electronically. And so once you get to that point, you go down, you file your paperwork, or you file it online, the e-filing system. Things have to be notarized. You do have to have your petition notarized, your signatures notarized, and you pay the fee. And then what happens is you get a date for the final hearing. That date is generally going to be 30 days. It's going to be 30 days from the date you filed, at least, maybe 45, depending on the court's calendar. But the point is, you get that hearing date very quickly, and then once you get to that hearing, you do have to prove that you're a Florida resident, so you do have to bring your driver's license with you. You both should be there because it's a simplified dissolution of marriage, and you let the judge know, yes, you do want to get the divorce, that you do not feel that counseling would assist you, and you go through that process. That's generally some of the questions that the judge will ask you. The judge will ask you if you both agree, if you're fine with the settlement agreement, and so on and so forth. And then the judge will issue a final judgment of dissolution of marriage. But just like in a contested dissolution of marriage, once that final judgment is rendered, you do have to wait 30 days to get remarried to anybody else. So, and the reason that is because there's a 30-day period of time from the date the final judgment is filed that somebody can appeal, ask for a rehearing, or appeal that final judgment. So that is the simplified dissolution of marriage. Easy peasy, right? Easy way to go. But if you have children, then you have to go with the uncontested dissolution of marriage. With the uncontested dissolution of marriage, you still agree with everything. And what happens is it's always best to go to an attorney, and it is always best to have both parties represented by an attorney, because that way we can make sure that all of the boxes are being checked with regard to finances, which include child support, alimony if it applies. What about retirement accounts, your assets, your liabilities, custody, the parenting plan, so many other aspects that go into it. But basically what it means, again, is you and your spouse are agreeing. It's time to get the divorce done, that you do want to do this as amicably, which means as nicely as possible, because that's just going to benefit the two of you as well as your children. So you enter and you have the attorneys, one of the attorneys, draft the marital settlement agreement with all of the stipulations that you and your spouse have agreed upon. And then that attorney sends it over to the other attorney, or sometimes just one party is represented by an attorney, which means then the spouse who is represented by the attorney hands the documents to the other spouse to review. Again, I still recommend that you go ahead and you have an attorney review them. But if you choose not to and you're fine with everything, then you go ahead and you sign it. Once both parties sign it, again, the signatures have to be notarized, so they have to be signed before a notary. At that point, then, you go ahead and you give the paperwork back to the attorney. The attorney prepares the petition with the marital settlement agreement attached. And you will also have signed, if you haven't, you'll sign, if you haven't already, the answer, the waiver of answer and service of process. So we're making this as easy for everybody. Once that is done, we go ahead, we file everything, but you still have to fill out your financial affidavits. You still have to calculate child support. So there are a lot of things that we have to do before, on the front end, before we get that petition filed and that agreement signed. We still have to complete the parenting plan. So there are things we still have to do. But once all of that is in the court file, then what the judge's assistant does is send us a notice that tells us when the final hearing is going to take place. Because it's uncontested, it'll go on the uncontested docket. A lot of those are being done still by Zoom, which is great. So you attend via Zoom. It is a little, unsettling because everybody that's on that docket is there that day. So it's not terribly personalized, unfortunately, especially with the Zoom hearings, but that's how it does operate. And you go in, you go through the same process that I just said with regard to the simplified dissolution of marriage. The judge is going to ask you questions to make sure you're both on the same page, that you're both comfortable, that you've agreed to everything, that nobody has promised you anything outside of the agreement, that nobody has harassed you into signing the agreement, that you understand what the agreement means, and that there are there's nothing else that is not known, and that you don't feel marriage counseling will help your situation. So those types of questions are going to be asked. And then once that is resolved, again, bring your driver's license with you, although we do go ahead and we file that in the courthouse, but we file it in a way that is not disclosed to the public. So at that point, the judge will enter a final judgment of dissolution of marriage, and then you are divorced. Again, you cannot remarry for 30 days because of that potential for an appeal. That is it. And so the process is pretty easy when it comes to an uncontested dissolution of marriage. The problem is when we have those contested dissolutions of marriage. So if you have any questions, if you would like to schedule an initial consultation, if you'd like any follow-up information, please go ahead and message me. You have on Facebook, it's DCE Law. On Instagram, it's at DCE Law, all lowercase. And you can also check out our website. We do have live courses coming up where you will actually be able to go through the process and walk through the process and do it yourself. So thank you for joining me today, and I hope all of you have a great, great Thursday. Ciao.